Now, Ms. Rose, in her opening remarks of you, mentioned that you championed many interesting pieces of legislation as AG. The Amendment to the Integrity in Public Life Act, Freedom of Information Act we're talking about now, Judicial Review, Proceedings Against Crime. What motivated you to actually develop and move forward with these types of innovative legislation within our country?
Well, as a young lawyer, when I came back to practice in Trinidad and Tobago, in practicing law, I realized that we had a very deficient system. And I realized that it needed legal infrastructure to strengthen the rights of people. Laws are normally passed to take away rights. And therefore, when I became an opposition member, I clamored for freedom of information legislation and some of the reforms. So when I became Attorney General, I felt that I got an opportunity to go to the cabinet with some of these measures, and I became very aggressive in the law reform aspect of it. I felt very strongly about Freedom of Information Act. I saw the injustice which was being done. For example, a public servant could not get information on his file, which a public service held, and which they were operating against him at times, and he could not get information. If you were involved in a motor vehicular accident and you went to the hospital and you wanted a copy of your medical report, you couldn't get that. It was a discretion which was refused on many occasions. If you had an inaccurate record in your file in the public service, you couldn't apply to correct that. So when I became the Attorney General, I felt this was the kind of legislation needed, and I also felt that you needed other legislation to strengthen the rights of the people. And that is why the Judicial Review Act was passed, in order to be able to make people enforce their rights, which meant that any public authority in Trinidad and Tobago, anyone which is unreasonable, which acts improperly, procedurally improper, or illegally, a citizen can challenge that, can go to the court, challenge, and get redress. And I even went further in that piece of legislation. If you could not afford to go to court, or if you didn't feel like going to court, but there was an important issue which affected you, a group, a public-spirited individual or public-spirited group can go on your behalf, but they do not have to show your consent in the public interest in getting the court to rule on the matter. And there are several other pieces of legislation which I don't think this is the time to talk about it.
Yeah, but surely, I mean, any administration would be fearful of trying to open up itself, or government on the whole, to public scrutiny. I'm sure members, colleagues in the cabinet will have been fearful of this kind of attempt.
Well, in some of the pieces of legislation, I got strong objections. But a country sometimes needs an Attorney General in a country under our Constitution is a very important office holder. And the Attorney General has to be very strong and has to know what his mission is, what the government mission should be, and ought to be prepared to take it through whatever it costs.
As you look back now, being former AG, is there any piece of legislation that you did not pass then that maybe you thought you would have liked the opportunity to pass that you do now?
Sure, there were many, but my time was limited because of positions I took. But I had in the pipeline at the time a law on referendum, And I believe that it's important to have that law because as it stands now in Trinidad and Tobago, the people have power once in 5 years. If you had a law which made it possible that in certain circumstances that the people can decide to have a referendum on a particular issue, even to remove a member of parliament, to remove a government, it would then mean that during the 5 years, the people would still have power. But now, under the system we have, whatever a government does, you could have the best will in the world, put in the government, whichever government, and during the 5 years, even if the government misconducts itself nakedly, the people are powerless to remove the government. They have to wait for the 5 years to remove the government. I think that is wrong. And I had actually a draft bill, and it was in the process of being done. And if I had stayed probably 6 more months, it would have been law in Trinidad and Tobago. There was another piece of legislation which had to do with the protection of persons who expose corruption and misdeeds, the whistleblower legislation. And if you remember, when I was AG, we also passed the piece of legislation dealing with the Witness Protection Program, Justice Protection Act, which meant that we could have protected persons who were witnesses and judges. For example, if I may quickly say, the Dole Chedi conviction and the gang being executed would not have occurred unless we had had witness protection program, because all the witnesses were killed and an accused person was taken and was made a witness, and I cannot tell you where he went because that is top secret, but he was sent out of the country. The gentleman had 2 wives. We had to send the 2 wives out of the country with his children, but he gave the evidence as a co-accused. And so I think whistleblower legislation is very important, because if people want to give information in order to, let's say, expose corruption, they have to be protected. And the whistleblower legislation which I had in draft was that that person would not be liable for any criminal, even if he was participating at the time, he would not be liable for any civil matter, criminal matter, or any disciplinary matter. But that has to be supported by a proper witness protection program.
Interesting you mentioned whistleblower, because you're also known as being a whistleblower yourself in 2001, in terms of the stance you took in the then administration. Looking back now, some 12, 13 years afterwards, would you have done anything differently? Or
No,
would you have done the same thing?
No, as a matter of fact, I have no regrets. As a matter of fact, I don't know if you remember, when I went to be interviewed to be a candidate in 2010, I was asked by the political leader of the UNC, who became the partnership, if I became the Attorney General of Trinidad and Tobago again, and there were allegations of corruption against the government, what would I do? I said, I will even expose it with even greater force. And, well, Mr. Ram Logan became the Attorney General. I did not become So I would have had no regret whatsoever.
All right, there's one last question. Because, I mean, as Margaret have mentioned, I work with the Freedom of Information Act and the Freedom of Information Unit. And England only passed their legislation like 10 years after ours. Yeah. And one of the person who is instrumental in that was Tony Blair, former Prime Minister. Yeah. Interestingly, though, after he demitted office and he became a citizen, there's autobiography, which is most Prime Ministers do autobiography, I guess, after they finish office. He said one of his regrets was the actual passage of freedom of information legislation in the UK. Looking back after you've demitted office, do you have any regrets?
No, as a matter of fact, I feel very proud that the freedom of information legislation is one of the matters that any time I have to go to it, I feel very proud that I've done that for Trinidad and Tobago. And if I remember, I think it's the only country in the Caribbean which has freedom of information legislation.
Next to Jamaica. Jamaica has it.
Jamaica
that's enforced. The Cayman Islands has it. That's enforced.
It had it before us?
No. We came first, then Jamaica came
first. That's
Jamaica.
what I thought, yes.
Other countries have, I think Antigua, Barbuda has it also, but it's not. It's just law. It's not enacted. Yeah. So there are 2 countries in the Commonwealth Caribbean that has it, Trinidad and Tobago and Jamaica.
And one of the things I remember doing in the legislation, because I had experience in the law and I knew that how it could be, I decided that whatever exemption, the court would have the ultimate power in deciding whether, even if it is an exempt claim, an exemption claim, the court can decide whether it's in the public interest. But what has happened with the legislation is that it has become too bureaucratic in that there's a lot of technical objections being taken. There's a lot of delay, and any government of the day can frustrate it can help to frustrate it, because what can happen, they can use lawyers to create all sorts of objections. And if it is that you take everything to court, what it means is that you can discourage people from using it. And if you do not have a legal profession which is assisting with pro bono work in doing these matters, it makes it very, very difficult. And that is why I think that it is very unfortunate in Trinidad and Tobago. I might get into trouble for saying this. It's very unfortunate in Trinidad and Tobago that the legal profession does not understand generally that its job is not only to go to court and do cases, it has a responsibility to the public to educate, to assist in doing matters like these. I want to congratulate Mr. Raymond because he has led the field in a very important case, which I think would be a landmark decision in the Caribbean in the freedom of information legislation. I think there's one which has been filed in the Court of, and it's now in the Court of Appeal.
Yes.
And there is one which is coming up to be heard in the High Court.
Yes.
But it shows that how that act with the provision that the court is the ultimate decider as to whether it's in the public interest was really a good thing to have done.